Hi, friends. I want to talk to you about the question, how important is courtroom presentation in litigation? Now, when I went to law school, there were a lot of people going to law school because of what they had seen on TV shows like LA Law. And, you go back through the history of courtroom dramas that have been on TV, and, you see a dramatic scene in the courtroom with two lawyers going at it with big rhetorical flourishes, and somebody comes in with some evidence that has just been uncovered at the last minute that blows the trial wide open, and justice is done, and that makes for good TV. It isn't typically what happens in a real courtroom. So I want to talk to you about the question of how important courtroom presentation really is, because I don't want to undersell it and I don't want to oversell it. I want you to have an idea of how much it matters. Well, in order to do that, I need to kind of make a distinction between motion practice and other pretrial kinds of proceedings, and then trials and evidentiary hearings, because the significance of courtroom presentation differs in those two circumstances. I'm going to try not to talk too much like a lawyer in giving some education on this, because I think it's important for every person to understand a little bit of this. So, without oversimplifying, I want to say we're going to look at litigation kind of in three phases. First, there's before a complaint is filed. You're going to gather as much information as you can. The lawyer's going to interview his or her client and other people that are involved, and try to put together, all right, what do we know about what happened, and and do we have a story to tell in court? Is there evidence for what we think might have happened and for the wrong we're trying to right by bringing this thing forward to court? Then we're going to file a complaint, which is the initiating document of a legal action. The opposing party, the defendant, is going to file an answer, typically. And then you go into what is called discovery, and discovery is what it sounds like. Subpoenas are issued, people are called in to give testimony and depositions, people make requests for production of documents, all that kind of stuff, so that the two attorneys are collecting from each other's clients and from each legal team the documents and other evidence that they know, so they know what the other side has, so that both sides can prepare their cases. And typically by the time you get to trial, both lawyers know what the other one has. And they're both familiar with the evidence that's going to come forth at trial. But in between the time you're doing discovery and the time you go to trial, there can be a wide variety of motions filed. You might file things disputing whether someone can get access to a particular document in discovery. You may have something that was prepared by an accountant that was working for the attorney, and there's a question about, is that document covered by the attorney work product doctrine? That one, just an example I pulled out of the air. You may have a summary judgment motion, which is where one side asks the court to decide the case in their favor without trial. And typically all of this motion practice, particularly a motion for summary judgment, does not involve weighing evidence. In other words, to grant a motion for summary judgment, for example, to decide the case in one party's favor without trial, you have to pretty much assume that the other party, that everything they're saying is true, that all of the testimony that they are offering is true, and even if everything that they brought forward was accurate, you still have to decide the case in favor of the party moving for summary judgment. And so typically in motion practice, whether you're talking about whether the other party has the right to discover certain evidence or whether you're going to decide the case in favor of one party or the other without trial, whether a particular party has violated the rules of the court, procedural requirements, any of that stuff, you're dealing with technical legal arguments for the most part. And the court, in most cases, is not in the business in those procedural motions of weighing who do I believe or who don't I believe. Or considering, what evidence is relevant or not. And in those cases, typically, the party making the motion will file a brief supporting that motion, and it will include a summary of what they believe are the facts that are relevant to the motion, not just relevant to the entire case, but relevant to the particular motion. And then it'll include their legal argument, the way they interpret the law or are asking the court to interpret the law. And then the other party will file an opposition brief to the motion. And then the initiating party has a right to file a reply brief. And typically that's all there is on a motion. There will then most of the time be an oral argument on the motion. There doesn't have to be. But that allows the attorneys to come in and present their argument, and more important, to allow the judge to ask questions of the two attorneys, to clarify their positions, to clarify how they're interpreting a particular legal case that's being used as precedent, or how they're interpreting a statute. And it's a technical legal argument between the two attorneys, and the court enters into that conversation asking the attorneys questions. And oftentimes the judge comes in to an oral argument pretty much with his or her mind made up. Not always, but very often the judge has a pretty good idea where he or she is going at the beginning of the argument. And what you're seeing in the courtroom has little impact on that. What matters more is the brief that was written and turned in, which many clients have never read. Now, I always send a copy of any brief I write to my client, because I think they have the right to look at it. It's what they paid for. But what I'm telling you is that even though it's not as glamorous, the written argument in the brief is far more important than the oral argument in the courtroom. And so when you're picking an attorney, you need to pick somebody who's a good writer. I know in one community where I have practiced, and I won't say where, there's one particular attorney who's very prominent, very wealthy, who is very eloquent in the courtroom, but can't write his way out of a wet paper sack. And all the other attorneys in the community know it. None of them would hire him if they needed an attorney. But he looks great to his client when he shows up in his very expensive automobile, pulls up to the courtroom and walks in to argue. And typically he's arguing a brief that was written by a junior attorney who is a better writer than he is. The writing is what you're paying for, particularly at the pretrial stage. So that's a very important skill set to have, the legal research, the writing, and having the legal judgment to kind of have an idea what will fly with the court and what won't. What kind of arguments are going to be successful and what kind of arguments are not. And you keep in mind that the judge does not want to be overturned on appeal. And so it's not whether you can make a creative argument. The judges are only going to be as creative as they need to be. And so as an attorney, you try to be only as creative as you need to be in making a legal argument, give the judge some cover and some safety, and help them arrive at a decision in favor of your client through the shortest journey to that point possible. Now, I mentioned we're kind of bifurcating this discussion to the pretrial and motion practice phase of a case and the trial phase of a case. Trial is very different. I've gone to trial a number of times in my career. Most of my cases, the vast number, settle before you get to trial. And if the attorneys have done their job, that's going to happen the vast majority of the time. Sometimes when you go into a summary judgment hearing earlier on, you get some hints about what direction the judge is leaning, and sometimes that helps you to settle. It gives one party an advantage in settlement discussions, and the other party is like, well, maybe I ought to take what I can get because it looks like the judge might be going the other way. So, anyway, when you go to trial or to an evidentiary hearing, that's going to be where what you've seen on TV plays out. The witnesses are called to the stand. Typically, they've been deposed or interviewed, and both sides have a pretty good idea what they're going to say. It begins with an opening argument where each attorney says, this is what the evidence that I put on in this trial is going to say. And they summarize what evidence they're going to put on and what it's going to prove. And then they go about doing that. And first, the plaintiff presents their case, and then the defendant gets to put on their evidence. One thing you ought to know is most of this evidence is going to be through examination or asking questions and cross-examination, where questions are asked by the other side. I won't go through all the rules of evidence, but if you're going to be a trial attorney, you need to know the rules of evidence, and you need to know when you can object to a particular piece of evidence being introduced. And good attorneys create a trial notebook where they look at each piece of evidence, and if you know there's something that you're going to try to keep out, you've researched your objection. Conversely, if you're the other side, you're going to try to anticipate, all right, what objections could the other side offer to this particular piece of evidence, and if that is offered, what am I going to say? How am I going to argue that? And sometimes if there's a jury, of course the attorney is not going to want to prejudice the jury by arguing that in front of them, and so they'll have a sidebar and go up and talk to the judge out of the hearing of the jury. Courtroom presentation matters more at trial. You need to know the rules of evidence. Having a persuasive opening and closing argument that clearly frames the legal issues and being able to argue your objections persuasively is important. There's a very famous trial attorney in Michigan named Jeffrey Feiger. You may have heard of him. But he's famous for asking questions in cross-examination which are essentially him testifying, and he's trying to put thoughts in the jury's mind, and it's abusive. It's not allowed. You could object to virtually every question he asks in cross-examination, but they're the kind of questions like, well, when you know, have you stopped beating your wife yet? Which implies that at some point you were beating your wife. You know, he's tried several famous cases, and that's his trademark. Is he asks these very antagonistic cross-examination questions that assume certain facts that are not necessarily in evidence. And I don't know how he's gotten away with it this many years, but he does. Anyway, so I'm telling you that in the pretrial stage, writing is much more important. In the courtroom, your presentation matters more, because you've got to be able to frame the issues clearly, and if you're in front of a jury, make it very simple to understand how they fit into the legal argument you're making. And then, and you've got to present that in a way that's clear and concise. And then you've got to have a closing argument that brings it all together, that tells the story. This is what you've heard, and this is what it means, and this is why the law applies to it the way that I suggest. So, overall, courtroom presentation doesn't matter very much. At trial, it matters a lot. And so I hope that that's, you know, given you a little flavor for how courtroom presentation matters in moving forward a legal case and its function. And if you have any further questions about this, or have legal matters that you need representation on, you know, I'm open to Zoom meetings right now, and would enjoy talking with you about your situation. So anyway, we'll talk to you soon, and hope you enjoyed this.